Doesn't your theory of injury rely on the assumption that if the HEROES Act isn't there, or if there's a problem with the HEROES Act, the administration would necessarily have done the same thing under the HEA?
No, I don't think so. In fact, I think the program will look quite different once it does go through negotiated rulemaking and notice and comment.
No, I guess I'm asking you, you seem to be assuming that if you get the relief of invalidation of the action under the HEROES Act, that the administration would necessarily move forward, because you said it was a top priority of this administration, that they would necessarily do the same thing or a similar thing, meaning provide debt relief to people under the other legal avenue. And I mean, I can imagine a world, if you think of a hypothetical, in which the secretary believes that that the department only has authority under the HEROES Act. Here we are in the midst of a pandemic. The intention of the department is to provide this relief in the context of the emergency, and that if we don't have an emergency, and that if we're not in this circumstance and we don't see the HEROES Act there, then they would not move forward. So I think you kind of have to convince us that the administration would have provided this sort of debt relief under the authority you point to that you say has the procedures that were not provided.
Two responses. I think the best evidence for this is the nature of the program. The program applies to 95% of all borrowers. It's not remotely tailored to individuals who are suffering from the pandemic. And the reason is because this is a program that's just designed to help people who are in need of debt relief. And on the authority point, the parties are in agreement that they have the power to do this under the HEA. And the secretary has never come up here and denied that they won't go through the exact same process, which they should have done in the first place, once this program is declared